Artslaw information session. Listen, read, learn. Artslaw.
This is an Anzac Day information session for Artslaw. I'm the Artslaw CEO, Louise Buckingham, coming to you from Gadigal land. So we're bringing this to you, our listening audience, our artists, arts organisations, clients generally, and other stakeholders who would prefer to access the information that we have on our website by listening to it. Having said that, the information comes from the website. We have what we call an information sheet entitled Using Symbols in Art, Flags, Coats of Arms and Money, including a little bit about ANZAC, Australian and New Zealand Army Corps it represents, and it's accessible, we hope, for those of you who prefer to read from the website. I'm just going to go through the information in the order that it's been collected and put together on our site. So turning to Using Symbols in Art, Flags, Coats of Arms and Money, we explain that symbols in art that can be trademarks, official coats of arms, money or flags may be used as powerful tools to convey meaning. But there are specific areas of law that arise or might sort of restrain or restrict use of certain symbols in artwork. So some of the things to think about that we go through in our information sheet include misleading and deceptive conduct under our Australian Consumer Law or ACL provisions. So our Australian Consumer Law prohibits people from engaging in conduct in trade or commerce that is misleading or deceptive. And using symbols can fall into this category if the symbols are used in business or in professional activities in a way that is misleading or gives a misleading impression. So use of something like a coat of arms or a flag, an official symbol, may be misleading, and it may suggest to consumers or audience, if you will, that there's an official link or approval or an endorsement from an official body. So, for example, if the Commonwealth Coat of Arms is used on a document, readers might think that that is an official government document. And so if artists are wanting to use the Commonwealth Coat of Arms in their work, and that might be perhaps to enhance the meaning that they're trying to convey, or they might be critiquing or commenting on something that the Commonwealth government has done, for example, they need to consider circumstances in which they're using symbols and flags and really ask the question, have I or have you created an impression that is not true and that someone else might be misled or deceived into thinking something different about? We then look at whether trademarks can be used in art. And it's important to understand that trademark law protects the symbols that are used by businesses to show that products or services are theirs, or in other words, they're meant to convey to consumers a genuine connection between the source or origin of goods or services that they have a trademark associated with. And that might be a registered trademark, but in Australia we also have what we call common law or unregistered trademarks that are used by virtue of use and association with the business rather than because an applicant has gone through the process of applying for a mark through IP Australia. But trademarks can include things like brand symbols, logos or brand names, and they can even include things like colour or sound that's associated with a particular brand. Businesses can register brand names or logos to get protection essentially against other people using them, or to enable them to take action against other people who are using those brand names or logos. But as I mentioned, in Australia we also have common law and unregistered marks, and our Australian consumer law provisions, including around misleading and deceptive conduct, can kick in if someone, for instance, deploys someone else's logo, even if it's not registered, to suggest a connection that isn't there. A trademark infringement happens when a trademark or something too similar to the trademark is also used as a trademark. So often using a trademark in your art, your visual artwork, or your writing, for instance, won't amount to trademark infringement because you won't have used the symbol or logo as a trademark. You will be depicting it as part of a landscape, for instance, or perhaps even to make a comment on something that the brand it's associated with has done. And use as a trademark really means that you've used the mark as a brand or to show a business connection between the goods or services and the person using the mark. Generally, if you include a logo in an artwork by way of comment or critique, or if you refer to a brand name, for instance, in writing, this won't amount to trademark infringement. We won't today go into the underlying copyright work, for instance, in the form of artwork, underlying artistic work that may be present in a logo, and the potential for copyright infringement that can occur by someone's use of another's trademark, even if they're not using it as a trademark. We'll leave that for another day. And for now, just say that artists generally need to be careful, particularly if you're selling something that includes a trademark, when you are looking at the logo that you're going to employ or utilise. For example, if you're selling t-shirts with your artwork on them and your artwork has a brand name or logo, this might be seen as an infringement depending on how it's been used. But bottom line, as always at Artslaw, our key piece of advice here is that you should ask a lawyer if you're unsure. So it's a good idea to get legal advice around any of these questions when they're concrete examples that you're looking at using. And we do have information that's more specifically geared towards trademark law and its application to artists amongst our suite of information sheets. If you're designing a logo or another trademark, you also need to think about whether or not you can include flags, coats of arms, and country emblems. You can't register a trademark if you would not be legally allowed to use it, or if its use would be misleading or deceptive. And there are additional rules about registering trademarks that contain certain symbols or words, including, and this is where we tie most closely into the theme of the day, and the word Anzac, including the coat of arms, flags or seals of the Commonwealth, a state or territory, the coat of arms or emblems of a city or town in Australia or a public authority or institution, flags of certain other countries, and also the word Anzac. IP Australia is responsible for registering trademarks in Australia, and they'll consider guidance from the government on the use of some symbols and flags. For example, you can use the Australian flag in a trademark design as long as it complies with the government's guidelines. And IP Australia has a practice manual known as the Manual for Trademarks, the Manual of Practice and Procedure, that includes all of the rules around what you can use there. Moving to using flags in art and the Australian flag. The Australian flag generally may be used in art, including for commercial use. If in your artwork you're wanting to use the Australian flag, for instance, your work might be being printed on products that are being sold, you might want to look at government guidelines to be sure that you're compliant. And the Department of Prime Minister and Cabinet has a guidelines on commercial use publication that is helpful in this regard. And if you have questions about the appropriate use of the Australian flag, you can contact the department. And again, so long as your use is not misleading and isn't representing that you have some authority from the government that you don't have, then the guidelines will be sufficient, but it's important to note they're just guidelines. Perhaps more sort of current, many people in Australia in terms of use and controversy that has been associated with it, the question of using the Aboriginal flag is one that's been front of mind for many in recent years in particular, and perhaps most importantly, in terms of the copyright issues and then outcomes that have been achieved that we'll talk about in more detail. And it's important to understand that the copyright in the Aboriginal flag until 2022 was privately owned, and that was because Wambai and Luritja artist Harold Thomas had designed the flag in 1970, and so as the artist of the artwork underlying the Aboriginal flag had copyright by virtue of fixing his artwork, his design in the form that he did, and that arose automatically and meant that as the first owner, he could deal with the rights that he acquired by virtue of that, how he saw fit. He did that and had arrangements, for instance, most recently with WAM Clothing and Flag World, which were ultimately undermined in a way or acquired by the government when it sought to resolve that the activity that was going on with the flag, including WAM Clothing in particular, having sent cease and desist letters to Indigenous organisations about their use of the flag, for instance, in the NRL Indigenous rounds and the AFL Indigenous rounds, to the understandable frustration and upset of First Nations artists and people. So part of the history underlying the Aboriginal flag and its use in Australia is the fact that in 1995 it was proclaimed as an official flag of Australia, and then against that, which involved it being a very public, iconic symbol, it was privately owned by the copyright owner, who could deal with the rights the way that he saw fit. Harold Thomas dealt with the rights the way he wanted to, and so only he could give permission to do certain things with the flags, like make copies or put it online. From the get-go, in theory, the public, including Aboriginal people, were restricted in terms of what they could use the flag for. But as is now well known, in January of 2022, the Australian government bought the copyright from Harold Thomas and arranged settlements with the companies at issue who had exclusive rights to use the flag. And the idea there was that this would free the use of the Aboriginal flag for all Australians, so long as they use it respectfully. So now the Australian government allows the flag to be freely reproduced by the public in all mediums, except the non-flags and pennants, banners and buntings, and Flag World retains its exclusive licence to manufacture the Aboriginal flag. Harold Thomas, the original artist, has retained his moral rights in the Aboriginal flag, and so in theory, if people use the flag in their artwork, Harold Thomas ought to be credited where it's reasonable to do so. There is a defence of reasonableness, in other words, within Australia's moral rights regime. But people, artists, should also consider whether their use of the Aboriginal flag might be considered to be derogatory in any way. And this brings us now to consider briefly the Torres Strait Islander flag. We deal with this also, and other state and territory flags in our information online using symbols in art. And the rules around the Torres Strait Islander flag are that if you're going to reproduce that flag in your art, you need the permission of the Torres Strait Island Regional Council. The flag is also protected by copyright. It was created by Bernard Namok of Thursday Island, TI, and Namok also has moral rights as the creator of the flag. And in 1995, the Torres Strait Islander flag was also proclaimed as an official flag of Australia. The 15 communities that the Torres Strait Island Regional Council represents together own copyright in the flag, and the council publishes information on how to seek and obtain permission to use that flag. Each state and territory in Australia also has their own flag. And in New South Wales, for instance, you're not allowed to print, issue or use the state flag in connection to any trade or business without permission. And that includes symbols which resemble or could be mistaken for being the New South Wales flag. If you want to use a territory or state flag in your artwork otherwise, it's a really good idea, as always, to get legal advice or check with the appropriate government department about what's permissible. There's a great source of information too on the Department of the Prime Minister and Cabinet's website. There's a booklet called Australian Symbols, which people might also find to be helpful if they're thinking about using any of these things in really any kind of creative art. Coats of arms are also obviously formal symbols of Commonwealth, state and territory governments, and they represent something that has official authority, and so they're officially granted by their king or queen. They're used by government and courts or with particular permission for use and have a strict set of rules attached. And because the coats of arms are formal symbols of authority, use without permission may ultimately be misleading. And there are strict federal, state and territory laws to restrict the use of official coats of arms, which generally mean that you shouldn't use coats of arms in connection with a business or any commercial activity unless you are the government or have specific permission. And you shouldn't use the coat of arms in a way that suggests you have authority when you don't. And each of the federal, state and territory governments has published information and guidelines on use of their coats of arms on websites. We list all of those in our information on the website and provide links to them, but they'll be readily accessed through Google searches as well for each state and territory. If you're making art outside of Australia and are thinking about importing something bearing a flag or coat of arms into Australia, generally will need approval under customs for that. Use of the Australian national anthem in work is also an issue for some creators. The lyrics for the Australian national anthem, Advance Australia Fair, were written by Peter Dodds Cormick in 1878, and there have been amendments since the original time of writing. And we know that in copyright law, a song can be protected in a number of different ways. And so the original music and original lyrics may be protected, and so may later arrangements and recordings. The original music and lyrics for Advance Australia Fair that were originally written by Peter Dodds Cormick are in the public domain, or copyright has expired in them, because the author, the creator, passed away in 1916. The federal government says that Australia holds copyright in the lyrics of the anthem in the form when the song was made official in 1986, and that it holds copyright in particular arrangements, and that must refer to the amended version because the original is in the public domain. So you don't need permission to use the 1878 version. However, if you're using later versions, you'll need to consider whether or not you're using a substantial part of the later versions, which is any important or essential or distinctive or vital, unique part about quality, not quantity. And if so, whether you need permission. And you might, again, be best placed to actually get legal permission on that question if you're planning on using the tune or lyrics in some way, including if that's for parody or satire and you're in some way modifying them. And there's a place that proposals for use can be submitted on the department's website, and again we have a link to that in our information on our website. I'm going to talk briefly now about use of Australian money in art, and then get to the issue of the word Anzac and the law. So answering the question of whether one can use Australian money in art, it's important to note that it is a criminal offence to intentionally deface, disfigure, mutilate or destroy any current Australian coins or notes. And defacing includes to cover some or all of the note or coin with any material. And so keeping intact any money that's used in any artwork is a sort of safe approach to responding to that norm, that rule, and artists may or may not embrace that or wish to comment on it in some way through their work. If you're using fake money or reproductions of money in art, you also need to be careful to avoid inadvertently counterfeiting, which is a serious offence. If you're reproducing banknotes or coins, you need to think about copyright the same way that you do use of anything in art. Australian banknote designs, for instance, and individual drawings on those designs may be artistic works for copyright purposes. And so another way of putting that is that they may be protected by copyright, which means you need permission from a copyright owner unless you're reproducing less than a substantial part of the work without the permission of the relevant owner. And again, a substantial part for copyright purposes is nothing to do with the quantity. It is all about quality and whether or not the part at issue is an important part of the original work. Of course, if copyright has expired, then the content is in the public domain, and that means that anybody is free to use it. The Reserve Bank of Australia owns copyright in banknotes. The RBA has given general permission to use images and partial images of past and present Australian banknotes, provided certain guidelines are followed. And again, we have a link to the relevant guidance in our information on our website. The Royal Australian Mint gives permission for the reproduction of images of Australian coins, and the Mint has also published copyright and reuse of materials policy, and generally it requires that permission is sought from the Mint if artists are reproducing coins, for instance, and some coin designs are collaborations and copyright may be owned in those by third parties or someone else besides the Mint. Like artists who designed flags, artists creating banknote designs or artwork that's reproduced on banknotes may also have moral rights in their artwork, even if they're no longer the copyright owner. The theme of the day, the word ANZAC, Australian and New Zealand Army Corps, and whether or not the word ANZAC is restricted in terms of use in art is the focus for now. So use of the word ANZAC is regulated in Australia. I know some people who think that the word ANZAC ought not to be used in conjunction with the word cookies. It has to very much be associated with the word biscuit or bickies to be truly Australian, but that is not part of the rule set. The regulations that we have mean that the word ANZAC and use of the word ANZAC in art without permission may not be allowed. There are also rules that specifically prevent the registration of the word ANZAC in a trademark. So regulations effectively prohibit the assumption or use of ANZAC or any word resembling ANZAC without permission for commercial purposes or entertainment. And commercial purposes include the application of the word to any goods created for sale or that are sold. And entertainment includes exhibitions and performances. There's an exception for events and entertainment that are held on Anzac Day, the 25th of April. And again, the Department of Veterans Affairs has guidelines that are available on its website for the use of the word Anzac, and they provide more information there, including on how to make applications to use the word. Guidelines state that the regulations do not apply when producing a book or a poem on the condition that the person producing the book is not a professional writer and that the content of the book or poem is historical in nature. The protection of the word Anzac comes from regulations from 1921, the Commonwealth Regulations, and again, these guidelines and regulations are available on the Department of Veterans Affairs website. The department is responsible for administering the regulations on the minister's behalf, and that includes in relation to the applications that are made. I note that on the website, the department says it processes all applications as quickly as possible, but suggests that people allow up to 4 weeks for the process to be completed and to be notified. And in the lead up to Anzac Day, sometimes this period increases beyond 4 weeks. And so perhaps if artists are planning on using the word for this particular day, you should bake in 6 or 7 weeks for the process of getting permission. Artslaw's information and the question of whether there are any other symbols that are restricted. The swastika and Nazi gestures are regarded as criminal offences in terms of their use under our federal law, and a number of Australian states and territories also have laws that prohibit, pain of criminal penalty, intentionally and publicly displaying a Nazi symbol, such as the swastika, perform a Nazi gesture. There are exceptions that allow for the use of Nazi imagery if the use is reasonable and has a genuine artistic purpose, perhaps for critique or comment on Nazism or a period of history, or perhaps on current events that someone has drawn parallels around. And the federal government has given the examples of displaying the Nazi symbol as part of a costume or set shown in a movie, which perhaps goes to that purpose too. Federal laws also require that any use of Nazi symbols is not contrary to the public interest. The Red Cross and Red Crescent, the symbols that are associated with aid in conflict, in armed conflict and war, and is associated with hopes for peace, I suppose, are also protected under specific laws in Australia. And the Red Cross, the cross emblem on a white background, and Red Crescent, which is a red crescent moon on a white background, cannot be used either for any purposes without permission from the minister. And that relates also to insignia, including the red lion and sun and red crystal, and use without permission is strictly against the law. And then finally, Olympic rings are protected as a copyright work, and the way that they're described as being sort of different to other copyright works, because they're meant to never go into the public domain. Unlike other copyright works, copyright in the Olympic rings doesn't expire. What is similar to other symbols is the fact that designs and trademarks featuring the Olympic symbols can't be registered in Australia. This has been an ANZAC information session for our listening audience. I'm Louise Buckingham, CEO of artslaw.
You have been listening to an artslaw information session produced on the lands of the Gadigal people of the Eora Nation. You can download the information which is accessible through the artslaw website, artslaw, artslaw.com.au.